Okay, then, welcome back to our next story. Now, former Kogi hempsman Yahaya Bello may be out of power, but he appears to be throwing his weight around. The anti-graft agency, the Economic and Financial Crimes Commission, EFCC, has declared the politician wanted for offenses relating to economic and financial crimes. The EFCC has also posted the former governor's photograph on its official Facebook page. Perhaps more depressing for the former first citizen of Kogi State is the withdrawal of all police officers and men attached to him. Now, get it straight. Former Governor Bello is a wanted man. That's a former, he's on a watch list as well. Jide, your state is in the news?
It's not my state, it's the former governor.
Here we go again.
I really want Yahaya Bello to be put on trial.
If he is deemed to have committed an offense.
Just let me, since it's my state matter.
Okay, you are owning the state. Go there.
I really want ex-governor Yahaya Bello to be put on trial so that we can know the truth. And when we know the truth, as the Bible says, the truth will set us free. I've had a lot of stuff. I've had, in this country, people who are accused of stealing billions and billions of naira were put on trial and they never got convicted. So even for Yahaya Bello's good, even for his own good, he should be willing to stand trial. You get the point. He should be willing to stand trial. Because it will help us discover some things. I am interested in discovering a lot of things about the way he ran the state, whether all of the money coming to the state, he alone was just chopping. We need to find out. You understand? I would have loved him to do what Ayodele Fawashe did. The EFCC made a lot of noise about Ayodele Fawashe. They said, we have notified the immigration, we have notified this so that he can, the Navy, so that he cannot escape through the waterways. They said a lot of things. What did Fawashe do? Fawashe decided to print a T-shirt by himself. He went to the EFCC, oh yeah, arrest me. Arrest me.
I don't come.
Today, he's moving around free. The same people who said, no, we've notified them, immigration, even the court granted him leave to go and get Medicare abroad. He went, got Medicare abroad. He came back. He trusted himself. The matter was going on. Suddenly, the EFCC lawyer said the judge was biased. The judge had to recuse herself, and they started Fawashe's trial fresh. Fawashe is ready. He's ready any day to meet the EFCC in court. But the reason you cannot expect Yahaya Bello to do exactly what Fawashe did is they are different people.
Yeah.
And the situations are different. According to Governor Yahaya Bello's aides, former Governor Yahaya Bello's aides, the EFCC never sent an invitation to him to come and face them at the headquarters for interrogation on anything. And you know why? The reason was because Yahaya Bello had secured an injunction. So they knew that a person who has a restraining order, you cannot, with common sense, then write to him to come and face you, because he will cite the fact that the court said, look, stop harassing this person and all that. The point that I'm making is they knew that with that order in place, they cannot compel him or get him to come and face them. Now, no matter how bad an order of the court may seem, what you need to do is set that order aside. you must get the court to set that order aside. Once you set that order aside, you can then move. But if you appeal an order, and the judge is yet to rule on the matter, even the matter of service, they are yet to rule on it. You then proceeded on the eve of the sitting of the court to try to help yourself by storming his residence. I mean, there are things that we cannot do. The EFCC, by the way they handle cases, allow a lot of politically exposed persons to get away. Because all it takes is to get a good lawyer. They have such a terrible record against politically exposed persons. If I'm to sit here and talk about politically exposed persons who have defeated the EFCC, sometimes based on badly prosecuted cases, due to carelessness, honestly, we won't live here today. And look at even what happened with a fellow Ibiraman, Adoke, the former
Attorney General.
The EFCC went to court. In open court, they admitted before Justice Kutigi that indeed we didn't have enough evidence. Come on. Now, I would have loved Yahaya Bello to go there. But if you didn't get an invitation, do you on your own simply go there? But the people didn't give him an invitation. They knew that he had a restraining order. And on the 22nd, the matter before the appeal court is supposed to be heard. Why wouldn't you wait until then? Because the judgment may even be in your favor.
Okay.
That's why people are saying, okay, there's a lot of drama about this. You see, the truth has to be told. Whether Yahaya Bello has stolen so much money, I don't know. Because I wasn't working with him. I could even be working with him and he will not let me know some things. But what we are saying is, the law is the law. Even if the order of the court, you feel terrible about it, you must obey. Otherwise, we are joking with anarchy. We must obey. There are ways in which you can set aside some of those orders. We've seen people give such orders. And then you get a superior court to set it aside, and you then proceed from there.
Yeah.
So this is the thing. All of this drama and all that, I just don't get it. Because it's not, at the end of the day, if they are not careful, the person that they've told us told more than 80, he will get away. Because of the way they do their things. It's just funny.
Doctor, in the past, we have, as he has said, we have seen prima facie cases being lost by the EFCC. So here we are again.
So many of it.
In fact, do you envy the EFCC chairman, Ola Olukayode?
Well, with the way he started and the promises he made, this is not a good situation for him.
And he's a lawyer.
Yeah, he's a lawyer. It's a very bad situation for him.
Well, he already admitted that a lot of the prosecutors in the EFCC, they take money from politicians. He said it.
He said so.
Have you forgotten?
You know, he said so.
He said so.
He said so. And that is not good for the agency.
Yeah.
It's not at all. Like BKO said, April 22 is on Monday. Court of Appeal says, come. You have filed an appeal against a restraining order. Why don't you wait?
Let's come on.
I've read somewhere where even some senior lawyers said a court cannot prevent you from trying somebody or from arresting the person. I don't know where that came from. Because what we say to ourselves is, let's do it legally.
Well, if a court can't stop you from arresting, why do courts issue
arrest warrants? Because it's an opposite kind of thing. You must.
Thankfully, we have a lawyer joining very shortly.
Yeah. So we need to go back and see also that there have been such restraining orders.
Yes.
In the past. The Minister of Defense is enjoying one. Bello Matawale is enjoying one now. A court has restrained the EFCC from arresting him.
I remember.
For 13 years, Peter Odili enjoyed it. Nyesom Wike prevented the EFCC from arresting the sitting governor in Rivers State through the court. So many of them like that. Abdulaziz Yari, former governor, enjoyed the same thing. So the big question people are asking is, why the interest in this case that will make you not to wait?
It was a few days.
A few days. And then political meanings have been read into it.
Yeah.
The EFCC's lawyer is the lawyer of a political party that Yahaya Bello's party defeated in the Kogi State election. How did you even allow that to happen? Because these are things you must take into consideration. In some cases in the past, that was why they lost.
Okay.
The opponent of the person you are trying and whose lawyer you are using is also the FCC's lawyer.
Yeah.
You need to avoid such
How do you
things.
reconcile this?
How do you reconcile them?
All right. Thankfully, we are joined at this point by a legal gentleman. He is a lawyer and advocate for good governance. Let's meet and greet Barrister Liboros Oshoma. I greet you, Liboros. Welcome.
Yeah, I greet you, Citizen Jones, and I greet members of the panel. Thank you.
So what can you tell us now?
I have listened to members of the panel, and when anytime EFCC starts their Gestapo melodrama, I just laugh because for some of us that have seen the beginning, we are no longer entertained by this, melodrama that EFCC is displaying. Really, gone are the days when we see EFCC, visit in a Gestapo-like manner politically exposed persons, and would think that yes, something good is coming out of this. For me, I think all of these it's like EFCC waits for a governor. The moment he exits office, they, come invite him, and then the drama will start. Some persons have said the next thing they will say, oh, you stole so much, or you give us our own. And then the case that starts with so much fanfare and drama will now take a snail speed. If you remember, Citizen Jones, Otubagbenga Daniel, just the same way EFCC, charged him for mismanaging, I think about 60 billion. Midway along the line, that charge was amended quietly to 200 million without the press, knowing. That was as far back as 2007. What became of the case today? This Yahaya Bello's matter, if you remember, sometimes in February, Yahaya Bello filed a case at the Kogi High Court in suit number HCL 68M 2024. Yahaya Bello, applicant, and the EFCC responded. Issues were joined in that matter. EFCC sometimes in February filed a 7-paragraph affidavit in opposition and a preliminary objection to that suit. It's an originating process for enforcement of fundamental rights. And at the end of the day, I think on the 17th, that same day, the Kogi State High Court delivered a judgment restraining the EFCC, like Otitoju has said. And one would wonder, really, we say prosecution starts from investigation. I read in the news somehow EFCC is charging Yahaya Bello to court the next day. And I asked myself, there's what we call the doctrine of presumption of innocence and audio utterance pattern, hearing the other side. Has EFCC taken Yahaya Bello's statements? Have they, taken his statement to hear his own side of the story? Or they will go to court, charge a man, because the Administration of Criminal Justice Act is clear. You charge a man to court without a statement from him, without hearing from him, and at the end of the day, is that not a way of boggling the case? Is that not the beginning of the end of that matter, where you have charged somebody, you have not even obtained a statement from him? You say, oh, we're taking him to court the next day, we're in his house, and then the next thing, if they had arrested Yahaya Bello, and then they took him to court the next day, is it after prosecution that they will now begin to obtain statements from him? Wouldn't that be a point of objection when the trial eventually begins, that most of these issues were preemptive. You know, I think that while I agree with Ototoju and my other brother that there's politically exposed persons, if anybody is found culpable, if anybody is corrupt, there's need for us to dutifully investigate such persons so that at the end of the day, the society will benefit from the taxes and the funds that is being pumped into, you know, the administration of EFCC. And not this kind of, you know, jamboree that we see. I can, like Otitoju said also, I can start to mention names, starting from, like I said, Otuba Gbengadane, Ojus Okalu, recently Anambra State Governor Willie Obiano, you know, and then Fayoshe, Adoke, all of this, including the NNPC, was it Kore, there was this man's name, EFCC, you know, the same fanfare. At the end of the day, there is something usually not tidy about the way these things are done, and you create a loophole for these persons to escape. Wouldn't it have been tidier? What's the hurry? Would it have been tidier you vacate this order of the Kogi State High Court? You're on appeal, the Court of Appeal was sitting yesterday, you vacate that order, you know, extend the invitation to this gentleman and obtain statement from him. Maybe after obtaining statement from him, there might even be some incriminating, you know, positions that you did not have your mind to before. And thereafter, it gives you a robust opportunity to approach the court. You would have tidied up your case, cross the T's and dot the I's. Unlike these haphazard ways of going to court because you want to please people that you're fighting corruption. And at the end of the day, the man gets to court, he's granted bail, and that becomes the beginning of the end of the matter. As a lawyer, I have never seen this kind of style before, where you arrest somebody, you have not even obtained a statement from him, you charge him, he's already in court the next day without a statement, and then it is when prosecution is going on that you now begin to obtain statement, and then you now say, no, you need to go back and investigate that matter. Wouldn't that be prejudicial to the accused person? And we know that in criminal law, if there is any doubt at all, any doubt created in the mind of the court, it is resolved in favor of the accused person. Yeah. And because the accused person is consistently presumed innocent. So I do not understand this style. There is no need, criminal prosecution, there is no statute of limitation to criminal prosecution. And that is why we consistently say prosecution starts from investigation. There is no need for this hurry, this fire brigade that we are saying. I would have expected that no matter how much, no matter how long a former governor runs, if EFCC is ready to catch him, like their slogan says, they will certainly catch him. I also would advise Yahaya Bello and co, let them pursue their matters to a logical conclusion, and then discuss with his lawyers, who mostly definitely will be senior advocates, and then let them approach the court, just like Fayoshe had done, approach EFCC from, like, I want to quote Ozekome. Ozekome had, you know, consistently informed Nigerians that care to listen that EFCC is a paper tiger, and that he has taken them to court 11 times, and he has defeated them. Why? Because of these seemingly loopholes that they intentionally created. That is why the current chairman, during screening, would say that prosecutors intentionally frustrate cases. Yes. Even investigation too, with what we have seen now, it's obvious that with this kind of investigation, definitely such a matter will not go far.
Liberals, let's look at this matter this way. There are some aides of the governor who are saying that because he had a restraining order, he felt that it would be disrespectful of the court for him to hand himself over to the EFCC. Do you agree that that action was right because he had a restraining order to not agree to be arrested?
If you look at the body of that judgment, the Kogi State High Court, if you permit me to read a part of that judgment, the Kogi State High Court, in granting that order, said, an order is hereby granted enforcing the fundamental right of the applicant to liberty and freedom of movement and fair hearing by restraining the defendant by themselves, their right servants or privy from continuing to harass, threatening to arrest or detain in any manner whatsoever, arresting, dealing, or persecuting the applicant on the basis of the criminal charge now pending before the Federal High Court, without prejudice to the powers of the said Federal High Court. Yes, there is a restraining order. Without prejudice to that matter that is before the High Court, there are procedures also for charging. I also, despite that despite the matter at the High Court, despite this restraining order, what the EFCC should have done at the appeal court would have been to argue the fact that their act empowers them to prosecute after investigation, and that there is no way they can prosecute without obtaining statements. And so if they are restrained without obtaining statement, then it will be impossible, a legal impossibility for them to prosecute. And to that extent that they pray the court to prosecute, to that extent they pray the Court of Appeal to vacate this restraining order. Once that is done, you can now extend invitation to the man to come answer to the petition or the investigation, preliminary investigation that you have conducted. But without doing all of that, you just you go to his house in a Gestapo-like manner and say you want to charge him the next day, and yet you have not, because the matter is coming up the next day, you have not obtained a statement from him. He can be a politically exposed person today, even if we don't like him. He can be Liberals or Shoma or Otitoju tomorrow, or Citizen Jones. And if it is you, nobody will even come out to speak. So, and that's why I think that no matter the situation we find ourselves, be it high and low, there are procedures that must be followed. These procedures must be followed to the latter, especially when it concerns the judgment of the courts.
Could it be that they weren't sure that they will get a favorable judgment? Could that be the reason they moved a day before they were supposed to appear before the court?
You can't preempt the court. You shouldn't be preempting the court. What that means is that you are trying to tie the hand of the courts. You are trying to tie the hand of the court by preempting that maybe you might not get a favorable judgment. If you believe that you have done all there is to do and you do not get a favorable judgment at the Court of Appeal, there is the Supreme Court. You can still go upstairs. So to not preempt, the courts even gave you a leeway, a window, without prejudice to the powers of the Federal High Court to prosecute, to carry out that criminal investigation, criminal charge. But the question is, this person that you are charging, have you heard his other side, his own side of the story? Have you obtained statement from him? Can you prosecute without obtaining statement from him? And now that there's an order restraining him, you need to vacate that order so that you'll be able to obtain statement from him to be able to prosecute him. It's as simple as ABC. We just make it complicated.
All right, Liberals, I understand what you're saying. Section 33 of the Constitution talks about the right to life, what should happen when a thing like this comes up. Let me reconcile what you have said with the fact that refusal to submit to arrest or detention is a crime in itself.
You see, the problem here is not refusal to submit to arrest. If a court restrains Citizen Jones from holding me, and Citizen Jones now come despite that court order to say, I must hold you, don't you need to vacate that order first that is restraining you? Yes. Or are we saying that, look, irrespective of how that order was gotten, irrespective of how it was gotten, the first thing is that it's an order of a court of competent jurisdiction. And mind you, EFCC had joint issues with the applicant in that court. EFCC were there. They filed a counter and a preliminary objection. An order and a judgment was given. EFCC has appealed that order. So, what is the hurry? In that case, if I were him also, I would say, well, I am protected by the law. You can't come and harass me as if I am a fugitive And despite the court, so if we cannot obey court orders, then why do we need to go to court? We should all resort to self-help.
We should all fight.
If there was no court order, restraining the EFCC, dated on the 17th of February, I would be among those that would say, Yahaya Bello, go like Fayoshe, wear a singlet and say, EFCC, I'm here.
I'm here.
But as a lawyer, I am restrained on the ground that there is a subsisting order which has not been vacated by superior court, and also by the procedures for prosecution, that you must obtain a statement from that accused person, except that accused person volunteers not to give any statement. Then it is recorded that the accused person was told in clear terms that he has the right not to say anything, and he volunteered not to stay, he decided not to volunteer any statement. So all of this will be recorded by the court. But a situation where you have not done this, you suddenly woke up after, mind you, since February, when the EFCC joined issues. They did not go to Yahaya Bello's house. They did not, and even then they have admitted that they did not extend the invitation to him to come answer. And then the man went to court and got an order. You were sleeping, he got an order. And now, all of a sudden, you remember, oh no, we have power. We even need to use the army to break into his house. This same thing was done.
Well, let me ask.
They broke into his house.
Let me ask. Yes, one of the reasons people usually give for not going to surrender themselves a lot of times is the manner in which they are interrogated and the condition. What do you say to our agencies on this?
That's why I support the current chairman. From pillars I get, current chairman, being a lawyer, has consistently admonished, members of the commission not to be hostile in interrogating suspects, because these people are presumed innocent. Do you know, let me share an experience with you. I have a matter with EFCC. For 2 years now, I have been begging the EFCC to declare the suspect that have absconded with my client's money wanted. They told me that there are a long procedure.
Sorry, Liberos, we are hard pressed for time.
They have not.
Till now.
Yeah, we are hard pressed for time. But thank you very kindly. Thank you very, very kindly
you
for your...
forgot to mention the fact that Emefiele got an injunction against the EFCC.
Okay.
In respect of his terrorism charge. Till today, that has not been vacated. That's why they charge him with terrorism.
Exactly.
Okay, we must go. But let's thank you, Babajide Kolade Otitoje, for joining us. Thank you.
Thanks.
Dotun Oladipo, many thanks for your time.
Thank you too,
One
sir.
more time, many thanks to Liboros Oshoma, an advocate for good governance. We're done. If you missed any part of this program, not to worry, join us later tonight at 11 for a repeat broadcast. And of course, on Sunday, we expand the field for you from 1:30 to 3:30. We are also on YouTube at youtube.com/TVC News Nigeria. I am Citizen Jones Hussein. Bye-bye now. Take care.